Today, we accept the court's opinion. It provides new guidance on the Impact Assessment Act, while explicitly affirming the right of the Government of Canada to put in place impact assessment legislation and collaborate with provinces on environmental protection. We developed the Impact Assessment Act to create a better set of rules that respect the environment, Indigenous rights, and ensure projects get assessed in a timely way. We remain committed to these principles, and we are heartened that the Supreme Court of Canada affirmed our role on these core principles. We will now take this back and work quickly to improve the legislation through Parliament. We will continue to build on 50 years of federal leadership in impact assessment. We respect the role of the Supreme Court in Canada's democracy, and we will follow the guidance of the court and collaborate with provinces and Indigenous groups to ensure an impact assessment process that works for all Canadians. Our immediate priority will be to provide guidance to our many stakeholders and Indigenous partners to ensure as much predictability as possible for projects affected by this opinion. We fully understand that we need to act in a timely manner. The Government of Canada wants to ensure clarity and certainty for investment in projects this country needs. This is exactly what the previous Harper government and senior ministers like Pierre Poilievre failed to provide. So now we will return to our homework and commit today to address this quickly and continue to make Canada an attractive and predictable place to invest in good, sustainable projects as we create and protect middle-class jobs and advance on a path of reconciliation. Thank you.
The majority of the court confirmed that Parliament can enact impact assessment legislation to, and I quote the court's decision, minimize the risks that some major projects pose to the environment, unquote. The court found that the Impact Assessment Act is constitutional in part, but that in some instances, the language in the Act needs to be more closely tethered to areas of federal jurisdiction. We, of course, accept the direction provided by the court, and we will be bringing forward the necessary amendments. Prior to 2015, under the Harper government's environmental assessment process, projects consistently got bogged down in years-long litigation because the old system failed to take into account how proposed projects could impact the environment and the climate, and it failed to incorporate the concerns, the perspectives, and the aspirations of Indigenous peoples. Good projects simply took too long or simply could not be built. Harper's gutting of Canada's environmental assessment process in 2012 eroded public trust and confidence in the integrity of the system. That is why during the 2015 election, our government committed to work with industry, environmental organizations, and Indigenous peoples across the country to establish a new environmental assessment process and agency, the Impact Assessment Act and the Impact Assessment Agency of Canada, to review major projects. This new process established a set of better rules that would ensure that Indigenous perspectives were included at the beginning of the review process, rules that guaranteed that important environmental concerns were highlighted and were addressed, and rules that provided clear timelines to ensure good projects could be built in this country in a timely manner. The Impact Assessment Act recognizes what the vast majority of Canadians know, that we should indeed be building major projects in a timely manner, and that to do so requires the active inclusion of Indigenous peoples and a focus on environmental sustainability. And while Canada must indeed continue to work to make our processes work as effectively and efficiently as possible, I would note that already many of our international allies look to Canada as providing a model of how regulatory processes should work. In fact, in very recent conversations I have had with both my Australian and my American counterparts, they have told me that they look to Canada to learn how to improve their own regulatory systems. As of May 2023, there are 495 major projects in various stages of development, many of which are critical minerals and clean energy projects that are under construction or planned for construction over the next number of years in this country. These projects have a combined capital value of $572 billion, which represents a 5% increase from 2022 in overall project count and a 10% jump in capital value. Progress is indeed being made. As I noted at the beginning of my remarks, the Supreme Court has found that in a few specific areas, adjustments to the Act are necessary to make it clear that the legislation is more closely tethered to areas of federal jurisdiction. But overall, the court confirmed that the federal government has the authority to regulate assessments of major projects. We will indeed be making amendments to the Act based on the court's guidance, We will continue to focus on upholding high environmental standards and respecting the rights and the interests of Indigenous peoples, all while providing clarity and certainty for project proponents. In the global competition for investment, Canada's project review process can be an important strategic advantage. Such a review process must allow us to move good projects forward in an efficient manner, but one cannot do that by ignoring legitimate questions and concerns relating to the environment and to Indigenous rights. Ultimately, our approach will mean more investments and more well-paying jobs in communities. It means accelerated progress towards ensuring Canada is a global leader in the clean economy. I must underscore that Pierre Poilievre and his Conservative Party want to return us to a time when nothing got built. They want to once again ignore environmental considerations and the rights and the interests of Indigenous peoples. Their approach will create uncertainty and gridlock, which will undermine the future prosperity of all Canadians. This federal government will build upon the work done to date. As I noted, we will be bringing forward necessary changes to the law to align with the court's decision, and we will continue to make project assessment and permitting processes work even more thoughtfully and more efficiently. We will continue to collaborate with provinces and territories as we are doing through mechanisms like the Regional Energy and Resource Tables, where we are talking about regulatory and permitting alignment. And we will continue to work with Indigenous peoples to ensure that they are treated not as passive observers, but as active partners and owners as we build a clean economy from coast to coast to coast. Before I conclude, I just want to acknowledge and thank the many interveners who stood with the federal government to defend this crucial piece of legislation, ranging from my province here of British Columbia to 11 First Nations, to the First Nations Major Projects Coalition, and to numerous environmental organizations. And to the provinces and territories who brought this lawsuit forward, I would suggest that we collectively commit to this being the last time we look to settle our differences in court.